I'd like to turn now to the second major change made by Proposition 36. This is the provision that now gives the ability of certain inmates to request resentencing as a second strike offender. The enactors accomplish this by adding Section 1170.126. It's an entirely new statute which deals with this remedy. The essential process is that a person who is serving a third strike sentence now has the ability to apply for resentencing as a second strike offender if they would have qualified for second strike sentencing had they been sentenced under the new law.
And that's going to go back to persons who have been sentenced for the last 28 years, assuming they're still in custody.
Absolutely. There's no time limit at all on the statute in terms of how far they go back. It's anyone serving one of these terms.
Is there also, Dick, a time limit under which they have to apply for this petition for resentencing?
Yeah, the statute's pretty clear. You have to apply within 2 years or later with a showing of good cause. So I think we're going to see an initial glut of these petitions, and they will quickly taper off because of the time limitations. We envision that there are 4 stages to the process. The first stage is the petition itself that's prepared and filed by the inmate. The second stage is an initial screening that's done by the court to determine whether the basic elements of the statute have been met. The third is what we call a qualification hearing, and that will involve several things. It will involve a reconfirmation of the statutory requirements, as well as this new element that Trish has mentioned, the element of unreasonable risk to a danger of public safety. And then the final step would be the actual resentencing, assuming that the defendant or the inmate has established the right to the relief. Let me start with the petition itself. I want to emphasize that this applies only to third strike offenders. Regardless of the term being served by the second strike offender, they are not eligible. Even if the second strike offender is serving an indeterminate term, for example, there may have been a second-degree murder, has the prior strikes, that would be an indeterminate term, but it's not being an indeterminate term imposed because of the third strike sentence. Those inmates are not eligible. It has to be a life term being served by someone because of a third strike sentence. The petition has to request the resentencing, and it also has to contain 2 basic facts. It has to contain a list of all the crimes, the current crimes that he's now serving time for, that resulted in the 25 to life sentence, and it has to list all of the pled and proven strikes that compose that sentence. Now, there's no prescribed form for this. The inmates are going to be sending these things in all manner and shape. Obviously, the courts need to be liberal in their acceptance of these petitions. As long as they appear to comply, they will be sufficient for consideration. But you can expect that there will be wide divergence over the forms that you're going to get from these people.
Do you have any indication from CDCR that the inmates or anyone else is making some type of form petition for this?
There's no indication so far that that's the case, and one might ask whether there'll be a judicial council form. There's such a narrow window here. I think it's unlikely that the council, because of its internal checks and balances, can turn a form around so quickly. But hopefully there can be some consistency developed, perhaps through some other means, some defense services or something like that that would help standardize it.
But we may end up with a 8.5 by 11 piece of paper with pencil writing as to exactly how it is that the person is petitioning for that, and that would qualify. There's no specific procedure on the statute indicating that it has to be done by some specific means.
Right, and there's no indication, for example, it has to be verified. It's just a request. Trish is now going to turn to that second stage, which is the initial screening.
We're calling this the second phase. It would be the initial screening after you receive the petition seeking resentencing, where it would be that the judge makes a determination of whether or not the petition is sufficient or shows a prima facie case, if you will. I'll start with indicating the fact that the statute indicates that it should be done by the original judge if possible. And I'm going to talk about that a little bit more. But here's what the petition you're going to be looking for to determine if it's complete will have. Is the defendant a third strike offender? Is he serving a life term? And is that life term based on a non-serious or a non-violent felony? If the defendant is serving the third strike sentence as a violent or serious felony, he simply will not qualify under a petition for rehearing. The second thing that a judge will have to do when they receive this petition is determine whether or not there is an exclusion that applies that will disqualify a defendant for resentencing. Now, there are two types of exclusions, and three of them. You'll be happy to know that they mirror the exclusions that we previously outlined as to whether or not a defendant, based on the current offense or based on his prior history, is ineligible for second strike offense treatment. So in other words, if it's not an excluded offense or it's not an excluded defendant, then the defendant will have made a prima facie case for purposes of the ability to seek resentencing. Again, Dick, we have this catch-all phrase because when you review the petition, I should step back and say when you review the petition, for most instances, it seems like a judge is going to be looking at the facts. Was the defendant convicted of a non-serious or non-violent felony? Is an exclusion applicable? And it will be pretty simple for a judge to compare the two to determine if they qualify. The only exception to that seems to be what we alluded to earlier, is that an exclusion is applicable if a defendant intended to cause great bodily injury. That may not be readily apparent from the initial screening. The procedure for initial screening, as I indicated, this must be done, and the statute specifically states that resentencings and this part seeking resentencing must occur by the original sentencing judge if that judge is available. Of course, if a judge is retired or otherwise another judge is allowed to make these determinations. For this initial screening procedure, there is no need for a defendant to be personally appearing. It's simply a review of the documents, as I've indicated. Does the defendant's prior history and current history qualify under the new rules for resentencing? Again, the only thing that may be questionable is the catch-all phrase of whether or not the defendant committed a crime with the intent to cause great bodily injury. In order to appropriately make this type of review, it seems like it would be impossible to make without ordering the defendant's rap sheet to see if there is some exclusion in the context of the rap sheet that would make the defendant ineligible for resentencing. So we are recommending that you order a rap sheet either from the prosecutor or CDCR or some other facility that can get that for you.
I might say that in that connection, in our materials you see a reference to what is available from CDCR, and CDCR has agreed to establish special liaison persons at each prison to facilitate this information being delivered to the trial courts, either because of a direct request by the prosecution or the court or whatever. So we hope that process will be facilitated and not take as long as it might otherwise.
I guess we should thank CDCR for being so helpful. Assuming you make this initial screening, you can deny the petition if that prima facie basis hasn't been shown. If the defendant doesn't show that he has met one of the qualifications in order to be subject to resentencing, you simply would deny the petition. On the other hand, if the qualifications appear to have been met, then you have no judicial discretion. You simply must grant the petition for rehearing.